The other issue that we see, though, is communication. And under a board, under the sort of the umbrella of an association, certain information is private. The meddler, often in the communication side of things, they sort of breach that confidentiality, right? There's certain data that they are privy to that they really are not supposed to disclose to others. And now we're talking about privacy violations. I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. So Jenny and Marty, thank you for being back on the show. I appreciate it.
Always fun.
So fun to be here.
So today's show is interesting because historically, when we look at association law and homeowners coming to us, there's the one part of, okay, where is the association going wrong? Where are they going? Where's the malfeasance? But the question is, what's driving it? Because unlike businesses, businesses are a bit more calculated. There's less emotion. But over the last 10 years plus, what we consistently see are certain personalities that are often driving these disputes, which we thought was interesting, saying, okay, not only looking at the association as entity, but the people that make up the association.
Oh, that's interesting.
Yeah. And so we're going to do sort of a series on the different personality types, because I think it's really important for a homeowner to say, okay, I'm dealing with X type of personality. And when you have X type of personality, how do you deal with that? How do you avoid that? And what are some of the byproducts of that personality that can make, your life a living hell? So I think it's important to identify and label these personality types because, again, historically we see it over and over and over again. So
that's interesting.
Nice.
With that foundation, the first personality type, and I think this one we see so consistently, is the meddler.
I feel like you're looking at me.
No, not at all.
I may have some characteristics.
We have no meddlers on the show. So
Fair
it's
enough.
it's a meddle-free environment. But really what we're saying and what we've identified is the board of director or the board member who consistently sort of goes outside of the bounds of their responsibilities and is really in everyone else's business consistently. Now, the problem with that, as we see it, is, as a board member, at least in California, they have a fiduciary to the owners. It's a fiduciary relationship.
Sure.
But for whatever reason, the meddler doesn't draw that distinction. There's no boundary, right? Where does their duty end? And because they can't identify that boundary, you see a lot of overreach. And because they're in a position of power, right? They're a director. It really gets
Complicated.
nightmarish for the homeowners.
Yeah.
Maybe one homeowner, maybe a bunch of homeowners. So I guess with that, from your guys' perspective, what would be the easiest way to access the meddler, the profile? What would you guys like to know? And that will help guide me in terms of what we've seen and the information that I can share on it.
I think maybe some specific examples of maybe cases that you've had over the years would be pretty interesting.
Okay.
Of the meddler.
Yeah.
Or personality traits specifically, and maybe a couple of examples with that as well.
Okay.
I kind of picture a woman walking with a clipboard. That's what a neighborhood I know of has, where she walks her dog with a clipboard, making notes.
Isn't there a commercial with like they're like waving at each other?
Yes.
And then they're like super cordial, and then how you doing? And then they take a chainsaw to the after the neighbor's talking. The neighbor takes a chainsaw and saws off the mailbox. He says above regulation, and it was making fun of HOAs, that it was just over regulation.
Person with a clipboard is a good example. I think nowadays in the more modern era, they're using drones,
Oh, wow.
right, to see what's in your backyard. Now, the distinction there is the drone, is the clipboard sanctioned by the board, or are they just they're taking an extra step? Right. And that's really what you're looking at. Were they sanctioned to investigate, or are they just investigating because that's part of their DNA? And so when it's sanctioned by the board, the board has a right to say, hey, we need to investigate, certain violations. We want someone to go out. It's systematic. They say, hey, look at all mailboxes and make sure all mailboxes conform. That's one thing. But it's different with a meddler who unilaterally says, I don't think they all conform. I'm going to go out and just sort of identify what I think is wrong. Because the issue there is that's where you start to get this selective enforcement. And I think that's one of the biggest byproducts of a meddler, because it's not uniform. It's not a uniform application of enforcement. It's, hey, you know what? I don't like this person. I'm going to go look at their house, right? They're sort of meddling in the affairs of others outside of what the board has sanctioned.
But is it always because they have a vendetta against a certain person, or is it just there's a power struggle, or they just are drunk with their own newly found power and just want to enforce?
Maybe all of the above. I think what distinguishes a meddler, though, it's driven out just by sort of a curiosity to sort of get into other people's business, but also a lack of boundaries.
Sure.
So it may not necessarily be motivated by some sort of malice. Certain personality types that we'll discuss down the road, it's malice driven. But a meddler, it sometimes just rogue curiosity.
Do you think most meddlers are specific, honing in on one person, or do you think that they're equally meddling in everyone's business?
It depends. I mean, we've seen both variations
It depends.
of the meddler. You have the meddler who is just sort of obsessed with a group of people, and they're all up in a group of people's business. It could be one person, or they just meddle within the entire community affairs. The other issue that we see, though, is communication. And under a board, under the sort of the umbrella of an association, certain information is private. The meddler, often in the communication side of things, they sort of breach that confidentiality, right? There's certain data that they are privy to that they really are not supposed to disclose to others. And now we're talking about privacy violations. So the meddler will have very sensitive information that's not supposed to be disclosed. And maybe someone's behind on their dues, or maybe there's some sort of outstanding issue with the homeowner that really should not be leaked. And next thing you know, they're leaking it left and right because they gossip. Which sort of leads me to maybe we should identify what are the characteristics of the meddler, which will help frame this out a little bit.
Okay.
And we wrote this down because there's a lot, but I like these characteristics. I think these are on point. So again, you have the excessive curiosity. You have the micromanagement tendencies, which, I'm trying to think of a good way as to how that manifests itself. But, I think hyper-focusing on maybe one or two people that they're just meddling anyways in their business. They're micromanaging maybe the HOA's approach to that one person or two people versus, again, that sort of equal, even-keeled approach to everybody.
We've all had the neighbor, though, that is just like always in your business anyway about
100%.
everything. And imagine that neighbor now has power.
Correct.
That is a nightmare.
Correct.
Yes.
Yeah, because the meddler in an HOA is one thing.
Yeah.
That's just a third party who's just up in the mix. But now you take that personality type, you put them in a position of power, that's where we see the problems.
Yeah.
So that's the micromanagement. Gossiping and rumor spreading, that's really where you're going to privacy breaches,
Yes.
potential privacy breaches or breaches of confidentiality. Selective enforcement I touched upon as well. That's the person with the clipboard targeting two homes because they specifically have an issue with them and they're trying to get specific information that they can bring back to the board and then weaponize the board against those two people. The lack of personal boundaries, this is where the board of directors is invited over to your home because they've invited themselves to sit down for tea. They gather information, and then they take that information and they bring it back to the board.
I'm guilty across the board with personal boundaries.
Well, we're not all perfect, but they also say know thyself, and I think you...
100%.
And are you on a board? Are you on the HOA board?
No, and that's why I'm not on HOA board.
and by the way, but here's the thing. There's nothing illegal with having that personality trait, obviously. The trouble or the problem is when you take that personality, you mix it in with that power, and then you execute, sort of in that framework, right? You're now taking your meddling, you're leveraging it, and you have a way to actually leverage it through an association board. That's where you have the problem.
Yeah.
So that's where the meddler becomes very problematic. Pursuing personal agendas. Again, I think that just goes to the nature of the meddler. They might use that information to gain an advantage, and it could be a personally motivated advantage.
What would be an example of that?
Yeah, let me think of a good one.
What about like a shared fence and you want to split the cost or something like that, where maybe you would use it to benefit yourself?
Well, boundary issues and fence issues are sort of their own category. So maybe putting that one aside for now, let's say a meddler lives next to another homeowner and the meddler's on the board, and the meddler goes over to their house, has tea, and the homeowner says, hey, I'm going to have this big construction project. I have this beautiful vision. And they're like, oh, let me see it. I want to know all about this project. And then the meddler takes that to the board and says, we need to shut down this project. That's self-interest. They actually do not want this project to go forward because of the potential impact on the meddler's life, notwithstanding the fact that the project might be totally legitimate under the Architectural Control Committee's guidelines. That would be self-interest, right? So now they're, again, meddling, getting all up in the mix on this construction project, and then bringing it to the board, and then using the board as a forum to drive their self-interest.
Personal agenda.
Another interesting way of using the construction situation as well. Let's say the construction contract was approved. Architectural Control Committee says, yep, high fives, your application is good to go. The meddler's next door and every day is talking to the contractor. Are you guys on time? What is this? Is this sanctioned? And just really sort of creating problems within the project itself, and to the extent that they're identifying issues or just manufacturing issues, which is another thing. Not everything the meddler does is necessarily true or what they communicate, right? They may fabricate the story.
But it also seems like, given in the construction, I mean, the meddler's driving down the road and sees a construction project and is meddling because they want to see what's happening inside there. And they're like, they want to walk the premise and get in there. Oh, what are you doing here? What are you doing there? And they really have no right to do so, especially if it's already been approved by the HOA. But they want to see exactly what they're doing because they're morbidly curious.
Yeah, and then worst case scenario, they take that unauthorized site visit and they manufacture things. They say, hey, I don't think certain things are up to code.
Yeah.
Which isn't true, but they bring it to the board in sort of this package of like, hey, they're doing unauthorized work there. Then the board is all of a sudden concerned, attempts to shut down the project pending further evaluation. Now, if anything, that's interference. They're interfering with the construction contract or construction.
No, 100%.
That's happening.
I feel like with so many friends, they'll be trying to be doing things without permits, or they'll go behind the scenes, and there's always a meddler that comes in and stops that and finds out about it.
Correct. And the question is, was it authorized? Was the site inspection authorized? And that's where the lack of boundaries, right? So if you're a neighbor, you're not on the board, and you say, hey, I want to check out this project, and you get authorization, that's one thing. If you have a meddler who's on the board and actually is just curious, wants to go in, looks at the project, that's fine. I think in and of itself, that's okay. It's when they take that as a chance to weaponize information using the board as a vehicle. That's not authorized.
Right.
That's where you have a problem. So those are the characteristics. And sort of if we look at the meddler, you have to look at impact on the community. And often what we see is it puts a lot of stress under homeowners. It might be a group of homeowners. It might be one homeowner. But it creates a situation where you don't have that harmony. I mean, ideally, an HOA is supposed to establish a sense of harmony.
Right.
Rules are in place, equal application of the rules. But now you have a bad actor running around, creating problems.
Well, you don't know that when you move in. You don't know how many meddlers are in your community.
Yeah, you might be able to read the CC&Rs, but yeah, how would you know if we have a meddler on the
watch out for your next door neighbor.
Well, you could talk to other homeowners before you move in. I mean, that's an extraordinary step. But if there's certain, you get a read of the community, maybe attend a community event. I mean, there's certain ways maybe you could access that information.
Let's hope you have a longer than 30 days, girl.
Maybe you could go online and look at the reviews of the community. Maybe on Next Door Neighbor, there's some information. I mean, I think there might be ways to access it. To your point, I don't know how quickly you can access that information. It might be worth at least doing an initial review.
Some due diligence, yeah.
Correct.
And how many homeowners are going to be completely truthful with you? It's a great community. You have to really infer some of the information.
Oh, 100%.
But some of our really bad cases, I mean, some of the homeowners will actually create YouTube channels explaining the problems. So when it's very, very bad, they do leak it to the public.
God, that seems like shooting yourself in the foot in terms of your own property values, though.
But maybe it is for the short term. But if you're looking long term, if you're going to be there 30 years, maybe you take a hit on fair market value for the first year or two because you're really trying to solve a problem. Because the association, if you have a meddler and they're turning your community into a dumpster fire, okay, fine. You put some more damage on it by putting this out into the community. But ultimately, if you solve the problem, if you put out the dumpster fire and you stabilize the community, your projection for the next 5-10 years, okay, it goes up. You're right. You might go down, but ultimately you're trying to drive it back up.
Yeah, if you get rid of, or even get rid of the meddler, then
Correct.
problem solved.
Correct.
Fair
All
enough.
right. So those are the characteristics. What else would be helpful for you guys?
Legal and ethical boundaries.
We've kind of touched upon that before, but like I said, most associations should be operating within the CC&Rs with understanding that they're a fiduciary to the community. The meddler steps outside of that. They take steps that fall outside of their role as a board member, and when they do that, that's where you have the potential violations.
So let's say that we're in a consultation with you
Okay.
right now, and we have a meddler, and we need to get it solved. And they're not ready to pull the trigger on attorney, but they really need some advice on how to handle this before it gets to the extent of needing an attorney, right?
Okay.
They need some counsel on how to solve this without legal intervention. And then maybe the second part of that is, when do you bring on legal intervention? Where's the crossover line where you say, I think it's time to get an attorney involved in this one?
Yeah. So first and foremost, if you can not use a lawyer and solve the problem, that's a win. Lawyers cost money. And if you can resort to self-help, that could be a huge win for you. So, if you're looking at a meddler, let me come up with a hypothetical. Maybe this person is leaking private information consistently to your detriment, right? Spreading rumors or disclosing information that's really confidential. So my first recommendation would be, before hiring a lawyer and coming in, with firepower, under at least California law, you have the right to demand what's called informal dispute resolution under the Davis-Sterling Act. And essentially the policy driving that is, California law wants to give homeowners sort of a platform to at least negotiate with their association before taking aggressive legal action. So IDR becomes sort of a platform that the homeowner can leverage and say to the association, hey, we have serious problems. Here are the problems. I am demanding informal dispute resolution under the Davis-Sterling Act, which really forces at least in theory, it forces the hand of the association to sit down with that owner in good faith to discuss the problem before legal comes in.
How does one initiate that? Because I would be totally lost on saying, okay, I got that advice, and I would have no idea about the law.
Yeah.
And how would you then, okay, you say enforce this, but how does one go about doing it? Do they have to write a letter, an email, knock on the board
doors.
member, hand them a piece of paper? How does that exchange work to make sure that you have all your bases covered there?
So the code contemplates, that an owner, non-lawyer, is going to be initiating this process. So there really is no magic language. Essentially an email to the management company or to the board with the subject line, request for informal dispute resolution, should suffice. And then the actual body of the email, right? Dear board, dear management company, I'm hereby, I don't know what to say hereby, that's too technical. I'd like to sit down with the board in a context of IDR or informal dispute resolution to discuss the following issue or issues. I mean, it's really simple. And it was actually funny. I was trying to make it more casual, and it was challenging for me, but it's supposed to be casual. So long as you say informal dispute resolution, you identify the issue, that's sufficient. And
under the Davis-Sterling Act, I guess here in California, they have an obligation to respond to that demand?
It's interesting. The spirit of the code is they have to come in good faith. They should accept it. A well-functioning association will say, yes, we will do this. Thank you for bringing this to our attention. We would love to sit down with you. The flip side, though, is if they reject it, ignore it, there's really no ramification to that. So it's, yes.
It should be difficult with a meddler and say they are the person that's getting a hold of this. Or they're the chairperson of the HOA.
Potentially, yeah. You could get stonewalled.
Yeah.
And so I think that goes into your second point when you bring in a lawyer. You try IDR and two things happen. One, they ignore it or they reject it. So it doesn't happen at all. Or you go through with the IDR, you sit there, the meddler is leading the whole thing, and they just shut you down. The meddler says, I'm doing nothing wrong. Of course I take your information and spread it within the community. What's wrong with that? So clearly you're being stonewalled. They're not seeing it for what it is. At that point, you may contemplate attorney intervention at that point. That would be the triggering point in my mind. Either a rejection or you just got stonewalled at the IDR. Hopefully, though, you show up at the IDR and there's 5 other or 4 other board members who see the problem.
Okay.
And you guys can actually troubleshoot and say, hey, you know what, this is a problem. Let's have a conversation with the meddler. And maybe that will at least create some transparency in the space where the other board members are on notice of the misconduct of the one board member. Because you got to remember too, the other board members may have no idea what the one rogue board member is doing. You kind of assume that they know, but they may not know.
Right.
So it might just change the DNA of the board after you put them on notice of the problem and actually have a positive impact with the board.
Is there a good place where a non-sophisticated homeowner or just, an ignorant one, like the layperson would go and outline the rules of conduct? Maybe it's under the Davis-Sterling Act that a board member has to abide by to see that they've actually crossed a line. I don't imagine them being outlined in the CC&Rs, but I want to know, hey, did they cross the line here? Where in the law does it show that they've crossed the line? So I have a little bit of evidence to go back at them with through this informal dispute resolution.
Yeah, so I think there's a little bit of a complexity there. That's where it does require more of a lawyer to step in to analyze that, because you got to remember, in California at least, you have the CC&Rs, or the governing documents,
Sure.
contractual obligations. You have the Davis-Sterling Act, which is sort of the umbrella law, and then you have case law analyzing all of this. So it becomes somewhat of a complicated analysis to determine what actually breach occurred and what's the appropriate resolution under the law. But I think at the early phases of this, I don't think the homeowner has to go that far to identify breach and consequence if they're having a problem with a rogue board member. That's sufficient to bring to an IDR table, to at least get it out there. And somewhat, there is a burden on the association to identify whether or not the association is acting illegally. Because what's likely going to happen, if you bring an IDR to the board and you write out the situation, on the back end, hopefully the association has a good lawyer who's reviewing this. And if the lawyer runs the analysis and says, oh my God, this actually is bad, this is a violation of the Davis-Sterling Act, or this is a violation of our fiduciary to this homeowner, even though the homeowner didn't identify it in that context, a good association lawyer should be able to identify the potential liability. And that might trigger the attorney on the back end, sort of behind the scenes, to step in and exert management control over the association.
Assuming the board or a board member brings it to the attention of their counsel.
That's correct.
Yeah.
But arguably an IDR in and of itself is a legal threat. It's a precursor to more serious action. So, a well-functioning association should have an automatic protocol. When an IDR comes in, it goes to counsel for review.
So I know you said send something a bit more casual, but if you're referencing the Davis-Sterling Act in that IDR demand, does that not automatically throw the flags up? Oh, these guys are serious.
You've done your research?
We've done our research. They're serious about this. They're referencing a part of the law, and that likely is to trigger the HOA's counsel to get involved and take it a bit more seriously.
I suppose you could always put on more bells and whistles, right? Your baseline
Sure.
is demanding IDR.
Yeah.
Your next, you could say IDR under the Davis-Sterling Act. And then if you really want to get fancy, you cite the civil code. I mean, there's ways to build it up and make it a little bit more threatening. But ultimately, like I said, there's no magic language.
Okay.
IDR in and of itself sort of forces the issue in front of the board and hopefully triggers at least an adult on the other side to look at it, meaning the lawyer.
But this also assumes that these board members, at least one board member it's brought to their attention and they're competent and they know their fiduciary obligations under them serving in the board.
Resolution under IDR presupposes a lot of things. Yes, competency, that they actually care, that they understand fiduciary, that they understand governing documents, that they understand the Davis-Sterling Act. So when you get to a board and you don't hit resolution, it might be one or a failure on a number of fronts. But at least it's a way to test those waters.
Yeah.
And by testing those waters, if they shut you down and say, hey, we can disclose confidential information, what's wrong with that? Okay, you got a big problem on your hands.
Yeah.
And that's why I'm advocating at that point, maybe then you bring it to a lawyer.
Sure.
And you can at least present a bigger picture. Because now the lawyer knows who they're dealing with on the other side, which is going to calibrate how they approach and how they attack.
It sounds like IDR is a great first step, though.
It can be, yeah. Or, otherwise, it could be a complete waste of time and energy. But
It
it's
can
not
go
a bad
either way.
it's not a bad strategy initially.
So, side note to this, it goes into a little bit bigger picture. When you are elected onto a board, is it commonplace where they give you any sort of training, or you're having some sort of pledge to certain standards, or is it just like congratulations and just sit down and listen? Do they have any sort of training does some of them have it?
It's
or-
all of the above. So it's high five, welcome to the club, grab a beer, and hang out with us by the pool, right? That is a makeup of some boards.
Yeah.
More sophisticated ones, there's an onboarding process where they're educated. Typically, that's outsourced by way of the management company.
Oh, that
The
makes sense.
management company might have an educational modular set up to sort of say, hey, you're now a fiduciary. Here are the CC&Rs. We want you to understand the bylaws. Here's how we run things. I mean,
Seems like there should be some informal education. associated with this,
that's-
at bare
one would
minimum.
assume, but it's not mandatory.
That's wild.
I mean, I suppose it's the requirement is that they comply. That's mandatory. How they get educated, how they understand what the gravity of their chair is, that's separate.
I wonder if there's a correlation between lack of knowledge and increased meddlers.
Well, I suppose it assumes whether or not the meddler is ignorant or knowledgeable and still meddles notwithstanding the knowledge.
Correct.
Sure.
Because you can have a very educated meddler,
This is very true.
right?
Yeah.
And sort of ignores rules and regulations, ignores the governing documents, and actually tries to weaponize those. That's a dangerous meddler.
Sure.
Versus just the incompetent who
Or the
doesn't
ignorant,
understand
right.
Or the
boundaries.
ignorant. Yeah.
Right? So
Interesting.
I don't know if there would be a correlation on that one.
It almost seems like when we've had discussions about laws changing in California, Florida, or wherever, it seems like a good baseline would be if you get elected to have some sort of training or something there. It seems like you could reduce so many potential disputes just by reducing ignorance alone.
So my thought on that, it's interesting. I've never contemplated that requirement. Part of the way association law is set up is to encourage people to volunteer to get on the board in the first place. If you start to create a barrier, you're going to have less people wanting to be on the board. And that could have a very negative impact on associations across California because no one wants to get on because they're like, I have 40 hours of CLE or, education. People may not want to run based on that, but how do you balance it, right? How
Right.
do you, so I mean, my theory, and
A
it's been
YouTube
this,
video.
maybe
Online
there's a required,
courses.
maybe there's a 2-hour crash course. I don't know what the answer is. I've been looking at this and my team's been looking at this for a while. Part of the question is, how do you ensure the association acts rightfully? How do you make sure that they abide by the fiduciary? You can put more regulation around the space, but if they're already violating it, what's more regulation going to do? The flip side of that is you ramp up ramification, consequence.
Mm.
And you almost run a deterrence theory in the law where it says, hey, here's the set of laws, here's the restrictions, this is where you need to operate. And if you operate that way, you're cool, everything's fine. If you step out over here, though, there's massive consequence that you'll be facing.
The board, or sorry, rather not personal, but the HOA would be in trouble.
Maybe both. I mean,
Okay.
you'd have to cut it. Maybe there's certain triggers that would put them in personal liability land.
Oh, interesting.
Others, it would just ramp up consequence against associations. So maybe if you do that, that would put a heightened awareness on the board, and maybe that heightened awareness would inspire education. They would want to know where the tripwires are. Maybe they don't care right now where the tripwires are because who cares? I'm not going to get nailed. But if they understand, hey, you could, and there's severe consequences, maybe that would sort of strong arm them into a position where they say, maybe we will spend 5 hours learning what we're doing here. Because you got to remember too, these boards are managing millions and millions of dollars of real estate.
That's
Right.
a good point.
Without
That's
question,
actually
yeah.
a really good point.
And it's not a position to take lightly, even though a lot of people do. And the boards that do that, the associations that do that, they do it really at their own peril. Because the owners do have power. They do have areas of attack on mismanaged or bad HOAs. So if you could really have those board members understand the role that they're stepping into, and I'm not saying you have to raise the barrier of education, but once they're in that position, once they sort of understand, hey, this is a big deal if we breach our fiduciary, if we meddle, if we convey confidential information to the community. There's ramifications for that that could be quite severe. Okay, maybe that just curbs the behavior in the first place and stabilizes the associations, at least within California.
Yeah.
That's interesting.
So, any other
Aw.
questions for Meddler? I think it's a fun topic, but the other ones I think are actually maybe a little bit more exciting. The other personality
That'll be our
types.
next episode.
Yeah,
I'm excited to get into the other ones as well.
Yeah, I think
There's
the
some
next
spicy ones.
I think
Yeah.
the next one is Tyrant.
The next one is Tyrant.
That's my favorite. So,
Okay,
all right.
we will look forward to that.
Well, thank you guys, and thank you guys for watching the show.
Thanks so much.